Hello, everyone. I'm Jean Lepremont, and I'm here in this virtual room with Tony Carty for what is another of our talks on questions of international law, legal research, and international legal scholarship. Tony, many thanks for being here today. It's
Pleasure.
it's a
Thanks for
great
inviting
pleasure. Today, we've agreed that we would be discussing questions of interdisciplinarity. And I know that this is something you've much to say about. The reason why we've picked this topic is, I believe, very obvious and self-evident. I mean, interdisciplinarity is very hyped these days. There is a strong expectation in the field that we should do and carry out interdisciplinary research. If you pull out an application for funding, it has to show interdisciplinarity. So yes, within the discipline nowadays, there is this sort of expectation to reach out to other disciplines. So it's a disciplinary requirement to do cross-disciplinary ventures. Tony, I'd like to kick off by asking whether it has always been this way. I mean, how were things when you started your career? Was there such a frenzy for interdisciplinarity at the start, or have you experienced a turn to interdisciplinarity in the last decades? Can you tell us a little bit more about how things were at the start of your career?
Well, my career, if I can call it a career, started in Cambridge in the years 1969 to 72 when I was doing my PhD. This was a solitary exercise where I came to look at the history of the writing of international law, historiography of international law. Nominally, the title of my thesis was quite a descriptive title, which revealed as continuing confusion about what exactly I was doing. I called my thesis The 19th Century Textbooks on International Law. And as I came to them, I then became conscious of the fact that this was a tradition that seemed to have lost its meaning. And it was working with concepts taken from the 17th and 18th century, which no longer had any resonance in the 20th century. And so I became myself very concerned. One could describe that as a kind of interdisciplinary history and law, or history and international law, but that's misleading, because I think interdisciplinarity supposes that there are autonomous disciplines in themselves perfectly sound that can benefit from interaction. Whereas my approach was very much that this was a legal discipline that had totally lost its way and was worthless. And so one had to try and understand what had happened and where it came from. And I had the opportunity, it came much later, but I had the opportunity to reflect on critically the work of Koskaniemi and Kennedy for a review that Bruno Zimmers commissioned for the European Journal of International Law as it was just starting. And there, the concept that I relied upon in order to criticize what was happening in the discipline and to at that time consider sympathetically the work of these two gentlemen was Thomas Kuhn's notion of paradigm, that international law worked with a Vatelian paradigm, having then superimposed upon it a kind of global federal concept of a world state, international legal order, and that all of these paradigms did not reflect significantly the dynamics of international society. So my view was that that basically one needed a radical rethink of the whole activity of international lawyers, and that is not really interdisciplinarity. That is the use of one discipline to basically wipe out another and reconstitute it completely. And consequently, that involved me in an exercise which was quite hazardous, certainly professionally. I remember, I think I may have mentioned this in our last talk, but when Gillian White, who edited The Decay of International Law, saw the title that I had given it, the book, while she had been on vacation, the editors of the managing editors of the journal said that theory of international law was too dull. Could I come up with another title? So I came up with the title Decay. And she said, my goodness, Tony, that really will challenge, threaten your career if you publish a book called this. So for me, I then find myself, and we can go on to many other concepts of interdisciplinarity, I find myself then confronted with the resistance to interdisciplinarity, resistance to any call to change the paradigm. And I thought about that quite a lot in preparation for our discussion today. And I would think that there was a conference held on called the Challenges for International Law, held in London. It was called the London Conference on International Law, LCIL. And it was basically organized by the British Foreign Office and by the British Institute of International Law. And all the great and the good were there. You had Rosalind Higgins and Vaughan Lowe, the former professor in Oxford, and it was wound up by Franklin Behrman. And Vaughan Lowe then was interviewed by the press, and he said, well, international law is now booming, and there are mushrooming of international treaties, there are international courts, and we have enough to do with the technicality of interpreting these treaties, studying the jurisprudence of the courts. And that consequently, he didn't say this, but consequently, there isn't really any need for interdisciplinarity. And there is a similar, I also was scooting around YouTube and different lectures to get some idea of where the profession is at the moment. I came across the same way of thinking in a lecture that James Crawford gave in the Chorley lecture of 2017 to the London School of Economics, which is also available in full. And he began his lecture in much the same way, saying that international law is now a highly technical and sophisticated discipline based primarily on international treaties and the interpretation and the application of these treaties to adjudication. And I think that is what the vast majority of the profession engage in. And they don't really, they have enough to do with that. And they don't really see that there is need for psychology, for history, for, I don't know, anthropology or whatever. I mean, the practical parameters of this discipline are perfectly adequate. And in fact, they, off the record, they can be quite abusive about interdisciplinarity and consider that this is basically for people who basically have no practice in the discipline. So there is and I have been reprimanded by leading figures. There's been some amusing comments on what I do, but I've been reprimanded by leading figures in the discipline, particularly in France, that really Carty should not be indulging himself with these pseudo-philosophical and ontological concerns and should simply get on with the practical exercise of the technical discipline. And a kinder but equally meaningless response would be to simply people compliment me on reading lots of different books about lots of different things, and that this is actually very amusing and interesting. But not necessarily implicitly implied in that is not necessarily that it doesn't necessarily lead anywhere. So for me, the notion of paradigm shift is a very radical version of interdisciplinarity, because it's placing a discipline in context in order to try to understand what it was originally intended to achieve and whether it is still fit for purpose. And I think personally there, I think it's not fit for purpose, and international lawyers have consequently marginalized themselves. And there I think that the role of the journals and the associations of international law are quite treacherous, because these reinforce a social world of international lawyers, which is actually, in my view, a bubble. So you have another very prominent international lawyer, very, very prominent, a judge of the World Court, a German, who said to me once, when I said to him, well, international relations scholars are very dubious about the existence of international law, to which he responded, well, we international lawyers are perfectly happy with ourselves and we don't care what international relations scholars think. In fact, another occasion of a person in a seminar I remember in Cambridge when I was doing my PhD, somebody came from the American State Department and gave a talk about international law and said that really it was very remote from the practice of the international diplomacy, and Robbie Jennings just sort of shrugged his shoulders and smiled. So we have, that's quite a long response to begin with, but it doesn't really, it really raises, in my mind, the question, why are funding institutions demanding interdisciplinarity for research? Because it seems to me that the majority of international law writing is quite comfortable with the monodisciplinary activity, commenting on international conventions, the drafting of international conventions, and commenting on international jurisprudence. One really does have a struggle. I think one has a serious struggle to put the changing paradigm approach to interdisciplinarity that I want to follow on the map. I mean, it's a constant struggle.
Yeah. No, I mean, I like your idea that there's actually a sort of discrepancy between the policies of funding institutions on the one hand and the practices of the actors in the field on the other. And so it seems that as far as I understand, you claim that the majority of those engaging with international law are actually happy with their monodisciplinarity, and they're possibly unhappy with the push by funding institutions for more interdisciplinarity. So does that mean that actually you are favorable to these policies by funding institutions? You're favorable to this push for more interdisciplinarity?
Oh, yes, definitely. But I still would wonder where it's coming from. It's coming from funding agencies that are primarily dominated by the social sciences and the humanities. And law has a very uncomfortable position there as being nominally, possibly in either social sciences or humanities, but very much monodisciplinary in both of these traditions and quite autonomous. I mean, I noticed, I've been trying to trace this. I'm on Academia EDU, and I'm trying to trace an article written with 3 other people by Florian Hoffman. And these articles come up on Academia because of some mention of yourself. And I then traced the mention of myself. And Florian is remarking that Carty has this interdisciplinary track, but within the discipline as a whole, he is completely marginal and has no impact. And though he wrote a very kind and thoughtful, though some people say critical, review of the first edition of the Philosophy of International Law for the Modern Law Review. I think that relevant to our discussion here is your own review of how Marty Koskiniemi has been integrated into the profession and the teeth taken out of his criticism. But we come to the funding agencies, I think they're simply dominated by social sciences and humanities. This is where the institutional organization of the discipline plays a role, because particularly, I think in all European universities now, the role of the independent third, what they call the Germans, I think, call Drittforschung, Drittgeld, that get money that comes from outside the university, from the research foundations, is supposed to play a significant part in the actual funding of the universities and in the funding of the academics, a crucial part. And so this is coming from outside the law faculties and puts pressure on the lawyers. So this is, I cannot really say any more about that. I have not applied for much of this funding. I obtained funding for my work on the British archives quite easily because I was studying the role of legal advising in British and French archives, and that obviously was historical work. It involved understanding the process whereby legal advice was requested and then what happened to it afterwards. McNair very famously, in his consideration of the role of legal advisors, Lord McNair insisted that this exercise of assessing the impact of legal advice in the Foreign Office was the work of a historian. And he as a lawyer could not really comment on this. All he could do as a lawyer was to comment on what he thought of the concordance or compliance of the legal advice with his understanding of general international law. So, but there are other areas now where one can speculate that international law is influenced by interdisciplinarity. Probably, I think probably the most important is the so-called turn to history. But I would like at a later point to explain where my own concept of a new paradigm actually leads.
Yeah.
And there, I have thought it useful to consider some articles. For instance, there was an article written by Francesco Messina, "Is there an Italian conception of international law?" And he wrote this in 2013. And I think he was a student of Crawford in Cambridge and studied state responsibility. And he argues for a universal, let's just say European legal positivism through various stages. And the one is to argue that the concept of the nation had to be eliminated from international law. And he discussed the transition from Mancini to Angelotti. And then from Mancini, you had the Italian nation, which expressed the character of the Italian people in all of its multiplicity, including its racial characteristics. And Messineo then simply dismisses this as outrageous and disgusting. And so we have the purification of international law by Angelotti. And international law is then the Jelinek concept of the state, bloodless and landless, totally colorless and harmless. You get the whole process also repeated in France. I did a study of French textbooks on international law, and there was an agreement among the various textbook writers that I read that the concept of the French nation was not a legal concept and was actually quite volatile and dangerous and had to be replaced with the notion of the state. And then the second step that Messineo, and that's why I think he's very helpful, the second step that Messineo takes is to say that the main focal point of international law is then the attribution of responsibility in the context of state responsibility. How do you determine what actors and in what circumstances engage the responsibility of the state in relation to other states? And this is the central and focal point of international law. In fact, this is really constitutional law. And to my mind, it's a mirage, because I try to argue, and this is really very complicated. I've only been coming to realize this recently, just how complicated it is. I try to argue, and it's crucial if you go back to the paradigm of the Vattel, that states are in a state of nature in relation to one another. There isn't an international legal order that brings them into existence. So there isn't an international legal order that actually attributes responsibility to individual aspects of the state. And what you have are nation states interacting with one another in a very confused and conflictual and ignorant manner in international society. And that this is actually, for me, what I mean by the need that I mentioned in my last conversation with you, the need to grapple directly with these interpretative communities, which I try to do I think in the most complete way, I try to do this in chapter 5 of the first edition of Philosophy of International Law, which is in the second edition, but clubbed together in a larger chapter on American cultures and American international law argument, where I take a background of American theology and American diplomacy for an understanding then an agora of the American Society of International Law on whether the invasion of Iraq was legal or illegal. And you then can see how the international lawyers in America are part of an American interpretive community. And when you see it in those terms, you can understand where they're coming from and what their phobias and anxieties are. And without that wider context, arguments with them are simply going to be, passing one another in the night. They simply won't understand one another. And I mean, I don't want to go on too long or allow you to come back with another question,
No, but there is already so much on the table. And actually, if I may, I'd like to come back to this Italian tradition you've mentioned, but also the French tradition of international law, which I believe are two traditions which are, I think, in the contemporary version, extremely monodisciplinary.
Exactly.
I think there is a great resistance towards interdisciplinarity in these traditions, because you've studied the genealogy of international law and you've read so broadly among authors of the 18th and 19th century. I'd like to ask you a question, a genealogical question, because it seems to me that this sort of monodisciplinarity of international law is a rather recent invention, and I think that's something you've been trying to show in your PhD work. Because if you go back as far as Grotius and you read Grotius, there was no intention. He had no intention to situate himself in a tradition. He obviously had a target. He had a target audience, but he never claimed to be belonging to a discipline. And he would borrow from theology, from classical Greek philosophy, from all. So when you read Grotius, it really reads as a sort of a-disciplinary work. Of course, the irony is that he was later elevated in the father of a discipline. But I think that Grotius is also the embodiment of, in a way, the rejection of monodisciplinarity. And so it seems that something happened somewhere, possibly in the 19th century, that there was this sort of, I mean, I'm tempted because you mentioned the dominance of social sciences, but I have the impression that international law became the victim of the social sciences catastrophe, this sort of Condorcet catastrophe, this sort of mapping and this sort of interdisciplinary order that was imposed on the humanities in the 19th century, and I feel we're still paying the price for that catastrophe.
Could you say more about the social science catastrophe and the Condorcet catastrophe? Because I think that you have your own passions here, which are very important for me.
Yeah, and maybe I'm making this all very dramatic, but I do believe that there was a time where what we were just people, intellectuals in the humanities, until a sort of disciplinary order was imposed on us, or on lawyers in general, and on anyone dealing with humanities, and then we were all put into boxes. I mean, what I mean by that is that the idea of discipline is a terrible mode of ordering. And when you actually, my take, I know it's a bit dramatic, but my take is that when you claim I'm a discipline, it's a bit like announcing you're turning yourself into a police state. That you're going to police your border, that you're going to impose order on people dealing with the topic. I mean, I think claiming you are a discipline is something actually quite dreadful, because it really means, don't bother me. I'm going to police the borders, and I'm going to impose a regime of truth on the population, and only certain things can be said. And things that are not allowed will be repressed. And so actually, I'm very uncomfortable with this idea of discipline. And I trace this back to these organizations of thinking and modes of knowledge in the 19th century, it might be earlier, and the division, the distinction between disciplines. I mean, the distinction between disciplines, in my view, is quite an impoverishment. And that's why I like what you do, because I do think you are someone who, you do not think in disciplinary terms.
No, no.
And actually, when you go and read all these authors, you don't think you're doing interdisciplinarity. You just read them because they're interesting and they have something.
Well, they're answering the questions, which I think are the questions that are bothering me. Well, there's so many points that one could make there. I would like to start, well, in case I forget, I would like to say that my understanding of Grotius is that he considered himself to be in what was still a Renaissance interpretative community of Europe. And therefore he resorted to all of the types of readings that he thought his intelligent readers would recognize. And that included the Christian faith is pretty central. An awful lot of the, despite his talk that the natural law could exist without God, the Christian faith makes up a very large part of his War and Peace book, but also the entire range of Latin and Greek classics and Greek philosophy, and including all of its dialogues, of anti-philosophical dialogues in the Greek tradition. They are very crucial. And so this was an attempt to persuade through a broad learning that would be significant. And I think that, without making any silly comparison, I think that this is what I think that one has to try to do now. We can come back to that. If one is to persuade, who are the people who are taking the decisions in international society? Well, there is certainly a scope for private international commercial law and commercial arbitration, and that can flow into investment arbitration. And there are technical aspects of immigration, technical aspects of criminal jurisdiction. But if you're interested in a high dynamic of international society, which has always interested me romantically, it's fascinating and it's obviously important. Like we take the bust up this weekend between Macron and Johnson over whether the north of Ireland is part of the United Kingdom. What is going on there is absolutely crucial. It has to do with a crisis in the Anglo-American identity. I've just come across, sent to me by Academia EDU, an article by a retired historian retired lawyer called Andrew Fraser, Anglo-Saxon republicanism and the rebirth, Anglo-American republicanism and the rebirth of the British nation. And it's an attempt to understand what is the crisis of culture that is taking place in. Oh yes, and the resistance to a global plutocracy. So the European Union is represented as a global plutocracy, and the democratic control now of the American state is a global plutocracy. It's basically Wall Street and woke culture combined. So basically, this is where the dynamic is going on. The hostility then towards China and Russia. I mean, I was quite shocked to read in the New York Times yesterday that Biden is going to meet with Putin in a couple of days, but deny him a press conference afterward because we don't want this disgusting little man to have any, profile. So the dynamics, the cultural dynamics that are going on, that is where, to my mind, to try and understand this collective psychology, this collective phenomenology of conflicting interpretive communities. Of course, the denunciation of China at the Group of Seven meeting has already been rejected in an equally mindless way by the Chinese embassy in London. So if you look at Messina, he's really quite contemptuous of Grotius and says, Grotius's book is full of all these quotations from these different authors, and he's not a proper lawyer, not like Gentili, who simply deals with contracts and treaties and so on. But I think that there is an ideology to the second point that I want to make, which is very sensitive, but we can leave out names. I have a long personal experience of France and Germany. As an Irish person, fairly rootless in the north of Ireland, I regard England as a foreign country. It's very congenial in some respects, in other respects it's completely unintelligible, and I don't understand it. So I have spent a great deal of my life in France and Germany, and I've been going to France since I was 14 years of age. And I remember when I was taking part with some French people in the project of droit du développement in the Maghreb in the 1980s. I met up with a Frenchman who ended up as the president of the University of Le Mans and west of Paris, not to be confused with Le Mans in Belgium. I did confuse it. And he told me that he had done his thesis in the University of Paris, Paris, Sorbonne, Paris too, with a, let us say, leading, if not the leading French academic international lawyer. And it was a thesis arguing against France having, the legality of France having nuclear weapons. And she said to him, you will never have a position as a professor of international law in France. And he never did. He went into university administration and ended up at one point as the president of the University of Le Mans. So he's not there now. I tried to check. Now, in Germany, one of my German colleagues, who is a member of a not too respectable political party, he said to me, but also an academic, a graduate from Oxford and a philosopher as well as a European lawyer, he said to me, the German international and public law faculties function as a policing force to maintain the discipline of German youth within the framework of the Grundgesetz, the basic law. So the concept of discipline means what it says. Discipline is discipline. And you are not supposed to go into this profession in order to think. You are supposed to go into the profession in order to learn the parameters of the official organization that it represents so that you can make it work smoothly. And I remember being in a seminar in Paris where a very prominent French professor of international law said, in the presence of Marty Koskaniemi, Marty was explaining some of his theories about law. And he just said, well, I don't know what all this conversation is supposed to be about. We are not supposed to be doing research. A professor of international law in Paris is not supposed to do research. He's supposed to teach. Research is not part of his function. So I have been told by prominent professors in Paris who comment on my work that it was time that I stopped thinking about, I come back to this again, about the ontology of international law. This is nonsense. There is a discipline to be practiced. Now, this discipline is not, in my view, particularly in the Anglo-Saxon world, this is not mindless or stupid. I mean, it does have a foundation. And the foundation is perhaps related to, in Andrew Fraser's view, and certainly this is a theme that I developed, it is related to plutocratic cosmopolitan capitalism, but they would see themselves as liberals and that law is based on contract. A law is based on consent. Formal subjects consent to rules and then apply them. So the row coming back from the plutocrats in Brussels to the romantics in London at the moment, the plutocratic Macron, the banker, to Johnson, the romantic fantasist in London, is you made an agreement, you made a contract, and you cannot now tell me that offends your identity, that this is something that doesn't suit your identity. So the argument really, to me, the most important argument about interdisciplinarity at the moment is to convince the formalists, the liberal contractarians, who have an ideology based in the notion of human autonomy and liberty, that they also need to recognize themselves as who they are in terms of their identity and the impact that their identity and their personality has on what it is they're contracting and agreed to.
Yeah.
So the issues are really very complex. And I go to other disciplines because I think they have the answers. I mean, the two clearest thinkers here are both Christian theologians that I discuss in my work. One is Paul Ricoeur. He's sometimes understood to be a philosopher, but he's an evangelical theologian. And the other is Oliver Odonovan, who was Regius Professor of Moral Theology at Oxford. And we're quite good friends, so we don't see each other too often. He became bored and frustrated with Oxford and left the place and retired to Edinburgh. I don't know whether he became bored with Edinburgh. He didn't have long enough to become bored. He was already near retirement. And he has written some wonderful books criticizing the whole contractarian theory of law, that it has it eludes the whole question of identity. And you see that with Massineo, that he goes from Mancini, who is talking about the Italian people, to this abstract Ancelotti theory of legal personality that I parody in my philosophy of international law. And I say, well, Ancelotti, who's followed then by Cassese, simply says an international legal person is a person to whom international norms are addressed. So you look at the treaty and see who signed it, and these are the legal persons. And then you become bewildered at the fact that these legal persons have different interpretations of the treaty, because you don't understand them as interpretive communities. So I think that the Brexit conflict at the moment can be interpreted from many different aspects. And even though my sympathies are with the European Union, and I would like to see the protocol enforced, nonetheless, I think that international lawyers simply have no possibility of understanding what's going on here, and they can't really intervene.
Yeah.
Yeah.
No, but I certainly agree with your claim that actually the answers to the greatest questions of international law will not be found in international law, and that we need to look elsewhere, and that we need to look to people as interesting as Paul Ricoeur. I'm mentioning him because I know you well versed in the work of Paul Ricoeur, and he's also someone that I admire very, very much. But maybe still sticking to the question of disciplinarity and interdisciplinarity for a little bit, my reservation is not against us going and read Paul Ricoeur, but it's about reading Paul Ricoeur and calling this interdisciplinarity. And so I'm a bit uncomfortable with the very idea of interdisciplinarity. I'm not uncomfortable with the practice that it refers to, because I think we should, if we want to be true intellectual, we should just stop reading the international lawyers and read those that have something to say. But I'm comfortable with claiming that this is interdisciplinarity. I think we should just do it without labeling it interdisciplinarity. And the reason I'm a bit uncomfortable with the very notion of interdisciplinarity is it's because it's a form of fake pluralism. You in a way, fake pluralism. You claim that, well, you're open, you're crossing borders, but actually by crossing the border, you reinforce the border. So you reinforce this ordering of disciplines by claiming you do interdisciplinarity. So you in my view, you perpetuate these 19th century distinctions between orders, between disciplines, between social sciences, just by saying, I'm crossing the border. No, just do it without saying there is a border.
I think that this brings us back to the, allows us to link up with our conversation the last time. The whole process of professionalization of the discipline that occurred from the time of the Institute being set up in 1873. And the chairs of international law were then set up in the different universities in England, France, and Germany, and in other countries. And this was a bureaucratization process whereby previously independent writers, essayists, we come back to this theme of the essay that we can also develop further later, is crucial. The notion that the essay is the work of an intellectual expressing his own personality, his own reading to respond to what he sees as issues of international society, is replaced by the bureaucrat appointed by the Ministry of Education to exercise a discipline. So the international law in the late 19th century in France is part of the reconstruction of the French state after the catastrophe of Sedan and the Franco-Prussian War. And the same in Germany and in Britain. Basically, this is also connected with another point that I mentioned last week, where on our last occasion, which is very well described by the neo-Marxist Jürgen Habermas, that the public space at the height of the bourgeois middle class epoch was a space of private individuals entrenched in families and family communities of independent income who could reflect safely and comfortably on their view of public society life. And it's quite remarkable that a Marxist presents such a sympathetic picture of the bourgeoisie at their height. But that, he says, is now completely replaced by the professional bureaucrat who has a specialized knowledge of a particular aspect of the functioning of the state, who is entirely dependent upon the state for his material well-being, and whose private family life is now replaced by a media and now even internet-infested public space, which is anonymous and all-embracing. And so the capacity for independent thinking and reflection has disappeared completely. And of course, I apply this criticism of Habermas to the International Court. And you cannot expect to have an international legal philosophy coming out of this court, because it consists of state officials who were either attorney generals or lawyers who were constantly advocates for their country. And these are the people appointed to the court. And they continue then as legal politicians in the court, in determining international law in terms of what they think is likely to be acceptable, either in the General Assembly or among the great powers. So the notion of independence is totally gone. And this is linked to discipline, because if you don't learn this discipline, you don't get into it. I mean, we have discussed with you already how a most prominent German international lawyer wished to do his dissertation, Habilitation, on Karl Schmidt. And Karl Schmidt is obviously a spectacularly controversial figure. But for better or for worse, I think I would not really hesitate to say, though this will shock and appall people in many circles, he's probably the most intelligent international lawyer of the German language, apart from Kelsen, who is his nemesis. And that's why I wrote a very long article about the pair of them, trying to compare them. And then both of them are immensely defective in many respects. And I go on then to look to a philosopher, Max Scheler, as a means of resolving the complexities of nation states in the world society, rejecting both Schmidt and Kelsen. But I mean, this person was forbidden to study Karl Schmidt because it is not acceptable in the German academic bureaucracy. It is not acceptable in the foreign ministry, which is very closely related to the research tanks like Max Planck Institute and so on. It's not absolutely impossible to study such a person, but you can only do so within definite boundaries and where the agenda that you have, that is to say one of consistent disapproval, is the dominant agenda. You cannot say this man has thoughts. But I mean, if you were an independent intellectual with an independent income, for whom writing was simply a recreation, then you would not be constrained. And I do find it remarkable that there is really wonderful critical thinking about international society going on in the United States. But it's really marvelous. This essay writing that Habermas so favors is actually flourishing in America, if you know where to look for it. It's outside the academy completely. It's among usually persons of independent income who've had some public experience, or journalists. Often the most prominent journalists are ones who have been sacked by their newspapers and are plowing an independent channel. The work they do is really, basically, it depends upon an economic and a spiritual independence, which brings you outside the discipline, which brings us back to the fundamental question, which we touched on the last meeting and probably can't resolve today, is what is the foundation of a vibrant essay writing culture? Because that is what we need. If we could turn all these overpaid, underworked professors of international law into essay writers who could reflect independently and critically on international society, it could quite transform it. But there are so many issues to do with contemporary international society. And I think I mentioned this to you last week, where you will find that international lawyers will not intervene because it would be indiscreet and embarrassing and would have a political cost.
Yeah, no, I get that, and again, I think we both share the same passion for essay writing, and I think a proper essay writing culture would actually require that we do away with a great deal of the disciplinary order. But obviously it's a uphill battle, because as you've just said, the disciplinary order comes together with a sort of bureaucratic order, and they actually go hand in hand, all of them working for some sort of state ideology. So this dream of an essay culture is well, at this moment it's kind of an utopia, because we have this disciplinary order which is extremely well embedded in our institutions.
That's absolutely true. And there is another matter which I think is related to another topic that you want to discuss in another in a subsequent meeting, which is postmodernism and the notion of public engagement. And there, I think that there is an essay you're probably familiar with that was published in the European Journal of International Law in 2014, Maria Aristodemou, Greek lady, a constant craving for fresh brains. And that is a total mockery of interdisciplinarity in quite a different context. That she's arguing from really a kind of nihilistic postmodern context that we have no foundation for critical or creative thinking, and we keep rushing around like headless chickens, trying to find them in different places. Not being able to find it in international law, we look for it somewhere else. I'm a bit more kind of romantic and old-fashioned in thinking that there are vibrant cultural traditions and philosophical and even religious traditions that can nourish us. But I mean, she takes Jacques Lacan as a paradigm case for demonstrating the inevitability of the destructiveness of our personalities and of our culture. So she's actually quite a fan of Houellebecq in France. And I think she's written more recently an article praising Houellebecq. But I think Houellebecq is essential for understanding the present contemporary culture. We are not to be naive. And he's part of our reading agenda, and is the reason why that you have been able to conceive of yet two more topics. One on the concept of whether international lawyers should be engaged in the challenges of world society, about which you have written also skeptically and critically. And secondly, whether this applies particularly to Europe, whether international lawyers are now part of a postmodern swamp of decay and indifference, and you cannot possibly expect anything of them. I mean, these are all very complex questions, and it's a very complex picture.
Oh, they are, and as you just said, these are topics we will return to, and I think there are two topics that we will be discussing in our next talks. I think one of them is the turn to history, but I think public engagement is another, and I think they deserved a more comprehensive treatment. If I may, and maybe that would be our final rounds of observations for today, but it's something which strikes me when we look at these calls for interdisciplinarity and these ventures into interdisciplinarity, these self-declared venture into interdisciplinarity, is the self-satisfaction that comes with it. Very often, those people doing interdisciplinarity, not you, Tony, but all these other people, they do it with an extremely self-congratulatory tone. I mean, look at the New Haven people. They say our agenda is interdisciplinarity, that's how we should do it, and we're very proud of it. And I do think that this is such a contradiction, because when you do interdisciplinarity, you come to appreciate that you can only be modest. You can only be modest because you're venturing into a universe where alien to you. You know that you're gonna butcher the materials you deal with. So you can only be modest. And I must say, I'm quite shocked by all the self-satisfaction of those colleagues that claim to do interdisciplinarity. This is not your case, Tony, and don't get me wrong, but I think there is a fundamental contradiction. You cannot be self-satisfied when you do interdisciplinarity. You can only be modest.
Well, I took issue quite strongly with I was a referee for Maria's article, and I took issue very strongly with it, with Joe Weiler and the journal, and I was overruled. My argument at the time has changed slightly from what it is now. My argument at the time was that she didn't carry through her argument and look at how it played out in the work being done by international lawyers. But subsequently, it has become clear to me that she had a particular agenda of her own, which is atheistic legalism, and that therefore everybody who is searching through interdisciplinarity is looking for a lost spiritual figure, which I think is true, but so what? I mean, how can she be so confident that this is a worthless and fruitless journey? I mean, she's confident of it because she has managed to master Lacan, who is I have tried to read and is an immensely obscure and difficult person. Or I do understand also even from her that he doesn't add a great deal to Freud, who's a lot clearer. And basically, there are, and this comes to your point, I did a little bit more work in the area, and this whole area of psychoanalysis is not surprisingly thoroughly contested among psychoanalysts. So I came across Viktor Frankl, and who detests Freud and considers him to be a destructive and malign influence. And so my question then would be, that what happens, what is very, very common in the profession at the moment, and I think this is what is troubling you, and it troubles me as well, is that each of us has to make a career, and so we go out and we explore some field and fairly easily make ourselves more knowledgeable in it than our colleagues. But of course not knowledgeable at a credible level among the persons in that field. But that doesn't matter because such persons are not listening. That's a different audience. And so you can come in, as I think Maria does, and bully people in the European Journal who really don't know anything about Freud or Lacan or anything else, and make it clear to them that, well, I know a great deal about this fellow. And I think that happens right across the board with post-structuralism, with linguistic theory, and also with history, that you sort of can beat down the opposition by spending more time than they are doing, devouring a certain text, but it is all a power game. And it is, I think that's what you're really referring to. There isn't a modesty there, because it is simply, I think Marty's article on between cynicism and conviction, or whatever it is, where he talks about how the different disciplines within international law, there are sub-disciplines like human rights and trade law, they battle with one another. And I hear Foucault's concept of the use of knowledge for power. I think, is quite clear, and Houellebecq's commentary on this kind of stuff is equally valid. So, I mean, I totally agree with you there. But then one comes back really to raw issues of the nature of spirituality and what is really motivating people when they're trying to understand things.
Yeah. No. I concur with these hegemonic strategies at work in interdisciplinarity, and there would be so much more to say. I think, Tony, these last comments are great, because I think they offer a nice bridge to our future conversations, which will be about the turn to history. I know you wanted to speak about it today, but I think we will devote an entire conversation to the turn to history. I think public engagement will draw our attention later, and obviously postmodernism. So thank you very much for offering all these very rich thoughts. Thanks for actually giving me making me eager to go back to Houellebecq. This is also another takeaway from a conversation. Tony, thank you very much. I look forward to our next conversation.
And thank you for the conversation we've just had. It's been a great pleasure, Jean. So goodbye then.
Goodbye, Tony.